There we go. Good morning, everyone. Thank you for joining us today. I want to welcome you to the number 4 program for our law practice management series this year, your law practice roadmap, practical guide for attorneys. Today, we're going to be looking at partnerships and personnel, who, what, when, and how to hire. And I want to let you know that we have one more program in the series for the spring. It will be on June 9th, your professional reputation, ethics, and civility. It will be June 9th, and 4:30 to 6. We'll be lucky to have Judge Virginia George, and Judge Terry Mockler joining Matt Gouchard and Craig Nevin to talk about etiquette in the courtroom, your reputation, civility practices, etc. So we encourage you to attend that as well. I also wanted to let you know that this is being recorded today, and we also will be having asking you to ask your questions through the chat function. We'll be monitoring that for you and asking questions of the speakers as appropriate. Let's see what else. If you want materials and attendance certificates will be sent out in the next couple of days. So if you have not gone into the CCCBA registration page and registered with CCCBA, I won't be able to send them to you because I won't have a record of your contact information. So if you could please do that, that would be great. Just because you registered with Zoom today and got the link doesn't mean you've actually registered on the CCCBA page. You have to do it twice. So you may have a confirmation with the Zoom link, but you also need a confirmation that kind of looks like the CCCBA invoice. So if you would do that, that would be great. Let's see, anything else? Okay, so I think we're ready to get started. I'm going to introduce our moderator today, who's James Wu. James is currently the chair for the California Labor and Employment Department of Quarles and Brady. He is also currently the past president of the CCCBA Board of Directors, and for over 24 years, he's been an invaluable resource to companies regarding their employment law and human resource needs, and we are so lucky to have him here today. So James, I'm going to turn it over to you.
Thanks, Anne, and thank you everyone for attending today. I know some of you may have already had a Zoom call this morning, and many of us have more packed in every day. So this is a joy to see you virtually on this call. Joining me today are two great panelists as well, and I have the honor of introducing them. I'll start with Danae Buddy, who is the managing shareholder of a 3-attorney firm in Walnut Creek, Buddy Law Group, a PLC, which you'll learn more about. Which is a 5-year-old law firm, or turning 5, I should say, this September. So congratulations, Danae. Previously, she was a partner at Alborg, Martin & Buddy, LLP. And she's been named a super lawyer for the past 3 years and is AV rated by Martindale-Hubbell. She is an experienced real estate attorney representing parties in many real estate transactions as well as litigation. She's tried over 50 cases to verdict, so she's well equipped to draft self-executing real estate contracts to ideally avoid litigation in the first place, but can handle that litigation if disputes do arise in the future. Danae received her undergraduate degree and master's in education from UCLA and received her JD from Santa Clara University School of Law. And also Danae is a former board member of the CCCBA. I'd like also to introduce Nick Casper. Nick is the managing partner at Casper, Meadows, Schwartz & Cook, where he has worked since 2007. Nick is a plaintiff's attorney, and he has been an active participant in the litigation of many of the firm's largest cases. These cases have involved wrongful death, catastrophic injury, products liability, child sexual abuse, and civil rights violations. Nick was named to the 2017 through 2020 Northern California Super Lawyers list and was on the Northern California Super Lawyers Rising Stars list from 2013 through 2016. And he was the board president of the Contra Costa County Bar Association in 2015 and served on the board from 2011 through 2016. And he was pulled out of retirement and served in 2019 as well. Thank you, Nick. So just a quick preview, we will be going through entity selection and entity formation and some considerations for those kinds of things. We know there's folks on this webinar who have different levels of experience and different interests or questions. You know, we will try to do our best to be very general, but also answer questions in the chat feature. But we'll talk about different entities and different considerations for them, as well as when you think you have enough work and when you know you need to broaden or increase your bench strength with staff, whether that be professional attorneys or whether it be legal assistants or secretaries, and we'll walk through some considerations with that as well. And of course, time permitting, we will also talk about transitionship and leadership in firms when folks are transitioning out and buyout agreements and ethical obligations to clients. So that's a general overview. But to start, I'll turn it over to Danae Buddy.
Thank you and welcome everyone. So I'm going to start with the idea that difference and distinction between being a solo practitioner versus setting up an S Corp. And one of the considerations that you want to think about, so you're going out on your own, you're setting up your practice. A solo obviously is much simpler, but there's no liability protection, which is why a lot of people will form any entity as opposed to just being on their own. But lawyers have options of either being a solo, a partnership, or an S corporation. As a lawyer, as well as certain other professionals, you cannot be an LLC. So when you're going out on your own and you want to set up your law practice, the things that you want to consider are, again, liability issues. Of course, you're going to get malpractice insurance that will hopefully help any potential liability you may have as a lawyer. But are you also going to be, and this we'll get into later, about hiring employees? That may have some role. If you're on your own and you're the only person in your business, then pretty much the work that you do is going to be things that you will be responsible for and potentially liable for which hopefully your malpractice insurance would cover. So you might think, well, I'm on my own, why do I need to set up an entity? What would be the rationale if I don't have any employees? And maybe you can certainly switch entities later. That may be a reasonable decision, again, if you are a solo. Maybe though, you want to look at client perception. Is there a different perception for a client if you are an entity, giving you a little bit more credibility if you are, say, an S Corp? You can be a single member S Corp. So I did want to mention that. You don't have to have other shareholders. That's kind of, as a solo, sort of your options. You can't obviously be a partnership, which Nick will talk about, because you need a partner to be a partnership. But you can be obviously either a sole proprietor or an S corporation. So is there a reason for client perception that you might want to be a corporation as opposed to just a sole person hanging out your shingle? Do you have corporate clients who somehow might see that as a little more stability? There are obviously additional costs if you set up to be an S Corp. You have filings that you have to file with the Secretary of State. You have to do separate tax returns. You have to have minutes. You have to have shares in your corporation. You have to do annual meetings minutes. You have to file annually with the California Secretary of State to keep your S corporation. So there is more cumbersome aspects to it. So if you're brand new starting out and you don't have clients, it might not be, you might want to start out as a sole proprietor and then perhaps create an S corp. You have to be very careful when you make those changes. The pros and cons, obviously, between the two. Sole proprietor is much easier. You don't really have to do a whole lot to set it up. You just run your business. It goes in and out. You don't have to have separate accounts, bank accounts. You presumably won't have any payroll because you're just you. The costs to set up, or one thing to think about too, is the cost of setup between the two. As I mentioned, there's more requirements if you are an S corp. And so you have certain setup costs that you would have. And then the other thing to think about is liability considerations, personal versus the business entity liability. And are there any tax, I'm not a tax attorney, so you would need to talk to a tax attorney, but are there any tax benefits or detriments for being solo, a sole proprietor versus being a corporation? If you're one person though, you don't set up a corporation, the default obviously is a sole proprietorship. If you're multiple people running a firm, the default, if you don't set anything up, is going to be a partnership. And then the other thing to think about is if you're associating in other counsel and, you know, you want to think about, well, am I going to add people? If, you know, what liability do I want to take on for other people? And again, if you're a solo, that liability, you're taking on all the liability. You don't have that extra layer of insulation of an entity. So those are some of the things that you want to think about when you associate with other counsel. You basically are taking on their, if especially usually you associate because either they're in a area of the country for which you're not licensed, or in an area of law for which you don't have the experience, but you still are dealing with if their liability. If they make a mistake, it becomes your mistake. So again, do you, as a solo, just be aware of that, but you may need to, because you may need that help from other attorneys to associate with in particular cases, especially if they're large cases. And I'll let Nick now talk about LLP decisions versus being a corporation.
Sure, thanks, Danae. And also remind me to circle back. I'd love to hear your differences in experience of being on the corporation side as well as being part of LLP. So in terms of our firm currently, I think today's panel, it would be useful to, especially when we get into staffing and employment issues, to really get into our personal experiences in managing firms. But just to kind of pull the curtain back a little bit, our firm has been operating in Contra Costa for over 40 years. I've been with the firm for, I think, going on year 14, and I've been a managing partner for the past 3 years. Before the transition in management, the firm operated as a professional corporation, or specifically an S Corp. After the transition, we created a new entity operating under the same brand name, but we are an LLP currently. And we have registered with the Secretary of State and State Bar as an LLP. And we're DBA, Casper, Meadows, Schwartz, and Cook. So that is, our firm has straddled both, although I've only been on the management side as an LLP. Generally, well, first, when there was a transition in the firm, I think this kind of touches on the general axiom, which I'm sure all of you have heard at some point, but the person who has their own client, or the person who is their own lawyer has a fool for a client. We felt that way going into this transition and wanted to consult with professionals in business formation when we were making these very important decisions, rather than try to kind of go through the self-help. It doesn't mean you necessarily would need to retain a business formation attorney when creating, when forming your business, but you definitely would like to consult with an expert in the field. Perhaps that's a lawyer that you know, or you can go through, you know, retaining someone formally. But it is important to, you know, make sure that you make that right selection. Danae touched on some of the issues that I'm going to also cover. The first being, there's really 3 main choices if you're going to be operating as a law firm. You can be a sole proprietorship, you can be a professional corporation, and usually that is an S Corp. Technically, you could operate as a C Corp, but almost all take a tax election as an S Corp. And that has important tax consequences, which really are above my pay grade, but there's definitely, I'm not sure of many C Corp law firms. It is correct, Danae, you could technically be a C Corp as a law firm? Danae?
Oh, sorry, I didn't. Yes, yes, and the reason someone might choose to be a C Corp is if you want to have different levels of stock. So if you have different levels of partners in a corporation, whereas if you are an S Corp, you're all going to, I mean, you'll have different percentage of stock or how much stock you own, but you can't have different levels. And so there's only the one class of stock. So that's why like maybe very large firms might choose to be a C Corp.
Got it. So, and then the third one is an LLP, as Danae already touched on. In California, unlike some other states, you cannot operate a law firm as an LLC. You have to be an LLP. LLPs are only available to a certain class of professional services, accountants, lawyers, architects, and of course, land surveyors. We all know that. And so LLPs and S Corps have a lot of similarities. For example, liability, both provide protection in the S Corp of shareholders and in the LLP of the individual partners from general liability that would not be extended if you were operating outside of an entity formality. So the important thing there to know is you're always going to be liable to the extent your own wrongful acts were tortious. So if you are the partner or shareholder who committed some sort of malpractice or actionable misconduct, you're never going to be shielded of your liability. Of course, you could get insurance to cover yourself, but you could be named in a lawsuit for those acts. But the difference with an S Corp and LLP versus working outside of one of those entities is you will not be liable personally for the acts of other partners or shareholders, or you won't be liable for respondeat type acts. For example, a staff member is driving a vehicle to court, and they're doing that in the course and scope of their work, and they cause a terrible accident, and it's their fault. The firm, either an S Corp or LLP, may be liable through the principles of respondeat superior, but you, as an LLP partner or as a shareholder of the S Corp, won't be vicariously liable for those actions through dint of the entity. So that's an important issue there, and why people choose LLPs or S Corps to protect themselves. There's different formalities for both. Generally, and Danae touched on this, the S Corp has more formalities that have to be adhered to keep your corporate status. And that's, going back to liability, an important thing, because if you don't adhere to formalities, for example, in the S Corp, maintaining minutes of meetings, filing statements with the Secretary of State, you could lose that corporate status. And if there was some sort of action against the entity, the litigant could potentially pierce the corporate veil and kind of find individual shareholders liable. So it's very important to adhere to these formalities. S Corps, you would have to have articles of incorporation. You would have to have bylaws. As Danae mentioned, for an S Corp, you're entitled to only one class of stock. So you can't have multiple classes of stock. You can have different percentages of stock owned by shareholders, but there can only be a single class. LLPs are a little bit more streamlined and a little less formal. You do need a partnership agreement. You do need to make a filing with the Secretary of State as well as the state bar to have your LLP registered. But there is not a requirement for ongoing formalities such as filing statements with the Secretary of State like there is for the S Corp. Danae mentioned this as well in terms of the importance of making decisions early on. It is definitely easier to think through all of the different advantages and disadvantages and select appropriately at the beginning than to make these changes down the line. If you start as an S Corp, it is often very onerous to go from an S Corp to an LLP because the S Corp, if it's formally converted, it will be viewed as liquidating the corporation. So it's a taxable event and can be very expensive. It's actually a little bit easier to go from LLP to S Corp, but not vice versa. But in any conversion, it's best to kind of make the selection appropriately up front and not have to do it to avoid really taxable tax consequences. In terms of taxation between the two entities of LLPs and S corps, they're very similar in some ways. They're both considered flow-through entities where the profits are generally reflected on the individual's tax returns. So in an S corp, that would be on the individual shareholders' tax returns. On the LLP, that is on the partner's individual tax returns. There is not, at least with an S corp, a corporate tax like there is for a C corp. In LLPs, likewise, although there is a filing of the LLP with the IRS and the Franchise Tax Board, the California equivalent, which I'm sure you're all very familiar with, but they're not taxed at that level. So you have to make a filing, but you're not taxed. There is a filing fee. I think it's an $800 annual fee you have to pay with at least the FTB as an LLP. But in terms of the profits of the LLP, those flow through to the individual partners and they are paid that way. And of course, each partner would be taxed based on their percentage of ownership, which would go back to the partnership agreement, which is the governing document of the LLP. But both generally the LLP and the S Corp avoid double taxation, meaning you don't pay taxes both at the corporate or entity level as well as the individual level.
Thank you, Nick. Sorry to interrupt.
No.
We have a question about something both you and Danae had mentioned, and the question is, can you also address the state bar's requirements with respect to LLP versus S Corp versus sole practitioner?
I can speak to LLP that the state bar requires you to register as an LLP, and you also have to complete and pay an LLP renewal every year. That renewal it's a boilerplate state bar form, and you have to let the state bar know if there's been any changes in ownership, if there's been any new partners added or removed, and some other basic questions. And then the filing fee is, or the renewal fee is fairly minimal. I think it may even be like, I want to say it's like $70 or something like that. But once again, it is a formality you would have to abide by. If you don't, technically, the state bar could revoke your LLP status, and you would then be operating as a, I guess, potentially a non-entity law firm where every lawyer would be individually liable if there was some sort of action against it. Danae, are you aware of the filing requirements with the state bar for an S Corp?
Yes, so it's very similar to the LLP, and actually when you choose, the other thing to be aware of when you choose the name for your law firm, if it's when you're not a sole proprietorship, that you have to get approval from the state bar, and you may or may not need to be a DBA. Typically, if you use the name, I happen to be a sole shareholder, even though I have other attorneys working for me, which was also part of my decision to be an S Corp as opposed to a sole proprietorship, because I was going to have other attorneys working with me, whereas it wasn't just me. But you do have the same filing as Nick mentioned, the renewal, the annual fee. When you set it up, you have to get approval from the state bar to use the particular name that you plan to use, as your entity, and annually you have to file. The other thing you have, and if there are changes in shareholders, you do need to advise the State Bar of that. Additionally, the State Bar wants to know if you have new attorneys that come to work for you, because they want to know who has access to your trust account. And so every time you hire someone, you do have to advise the State Bar, and that doesn't have to be a partner or a shareholder in an S Corp situation, another attorney for the purposes of the client trust account. Even if they don't have access, even if they don't have rights to sign, that is something that the State Bar requires. And I assume that's probably similar for the LLP.
Any idea if there's requirements for sole practitioners?
For filing with the State Bar?
Correct, yeah.
Well, you're a licensed attorney. So again, assuming you're practicing under your own name, the issue would be is if you try to be a different name than who you are, because the whole reason we do filings with the Secretary of State and the State Bar when you're a corporation or an LLP is sort of to have transparency for the public, to know who are the people behind this organization. So I think if you're solo and you're practicing, if I practice as Danae Buddy and I'm just Danae Buddy, it's transparent of who are the people. So I think, but if you choose to use a different name than your own as a lawyer, then you're going to have certain State Bar requirements, again, from a transparency standpoint. So if someone is dealing with XYZ law and it's Joe Smith, who's actually XYZ law, even though he's solo, he's going to have to inform the State Bar of that and be a DBA for transparency.
Great, thank you.
Yeah, and the State Bar, at least for sole practitioners, they may also potentially reject names. For example, if you're a sole practitioner and you're, for example, Nick Casper and Associates, and I'm the sole lawyer with the firm, the State Bar would likely reject that because it's essentially misleading the public. There are no associates with your firm. But other names, as I'm sure you've seen out there, on billboards, for example, people do kind of push the envelope of law firm names, and obviously those aren't those people's actual names, but generally it does require registration with the State Bar and approval and annual renewals.
Great.
Yeah, and I'll mention that the same is true with an S Corp. So, you have to, if your name is not in the name of the business, you are going to have to be and that's really not the State Bar as much as, whether you're a DBA, you cannot be a group, for instance. Even though you can be an S Corp as a single attorney, you can't be your name in a group, because a group also requires there be at least one other person. It actually doesn't have to be an attorney, but you do have to have someone else working with you to have the name group. You also have to have at the end of your S Corp, you can be a professional law corporation or a professional corporation. It's kind of like the Inc. idea when INC, when you are an incorporated business.
Right. And I think you may have mentioned already that whatever entity, we also need to make sure to, especially in Contra Costa County, go check with the county clerk's office for any fictitious business names and get a business license and those kinds of things with our, either with the county or with the city if the city requires it as well. So there are also local requirements in addition to State Bar or other requirements.
Yes, and that's an annual, you have to get a license every year with, I know for instance, Walnut Creek requires an annual payment for my business license.
Right. And I think in terms of the city ordinances for business licenses, very important and to calendar those accordingly. But I think the penalty, if you fail to do that, would be a civil penalty, a fine. You wouldn't necessarily lose your entity status for failing to have a business license with City of Concord or City of Walnut Creek. But you also would want to not do that because you will get fined.
And that's true with your filings, oftentimes with the Secretary of State. State bar is probably a little stricter because, again, they're protecting the public from lawyers. But the Secretary of State, if you're late on your filing, for instance, of your statement of information that's due every year as a corporation, you don't necessarily go defunct, but you will pay a hefty fine for being late.
Great. And just so the attendees know, the chart that we showed prepared by Danae and Nick, we will be providing that to you, a soft copy through email after the webinar. So you will receive that.
And just, I just wanted to finish up real quickly on some kind of more kind of prominent distinctions between S Corp and Llp. I think I forgot to mention this. There has been a general movement for firms over the last 20 plus years to go to an LLP form versus an S Corp. There used to be more pronounced tax advantages to be an S Corp that kind of were changed in the 1980s. Since that time, most firms and even large kind of silk stocking firms choose the LLP form because one, there's less formalities required, and two, there's not any distinct tax advantages of being an S Corp over an LLP like there used to be, and three, there's more flexibility to the structure. We've hit on some of those issues. For example, LLPs, you can be, in terms of the governing document, it's the partnership agreement, and you can really be very specific in different ownership interests of the partners and different classes of partners, whereas S Corps, you can only have a single class of stock to the shareholders. And that is important for allocating profits amongst shareholders or partners. So it's much easier to dial in and change in an LLP form versus an S Corp. The other important distinction is flexibility. There's a lot more flexibility to add partners in LLPs than there is with shareholders. Shareholders would require filings with the Secretary of State. The stock would have to be reissued and redistributed, the shares of the corporation, instead of just amending the partnership agreement by vote, and then you've already satisfied the formality of adding a partner. So there's just a lot more flexibility. And for the largest firms, there's no limit to an LLP. There is a minimum, you have to have at least 2 lawyers, but there's no upper limit. So you can have firms with hundreds of lawyers operate as an LLP, whereas I believe an S Corp has a maximum number of attorneys, of 100 attorneys or 100 shareholders. Not really an issue in Contra Costa, as I don't think there's any firms with 100 attorneys. There may have been in the past, not anymore, but definitely an issue when you're talking about firms that operate multinationally, operate in different states. How many attorneys are with your firm, James Quarles?
Over 500, and it is an LLP.
Right. So if I were to give one bullet point for everyone to write down, it would be to choose wisely and correctly up front. Obviously, if you're a single lawyer, you wouldn't have the LLP option up front. And also to consult with the experts when making these decisions. Self-help is great, but it's such an important distinction that it really makes sense to consult with that attorney friend who specializes in entity formation, or to actually retain counsel and have them draw up your governing documents and to advise you accordingly.
Great advice. Let's transition now. It's actually a good point. Now that we hopefully have an idea of what entity we'd like to operate under, we're ready to grow. But how do we decide, or what calculus maybe the two of you went through when you're deciding, okay, how do we know when it's time to grow, and are we ready, and can we support that growth? What are some of the ideas or pitfalls or obstacles you guys dealt with in that analysis?
Sure, I'll start. So when I went out on, and what happened was my prior partnership dissolved because one of my partners became assistant general counsel for one of our corporate clients, and now is general counsel, and other partners retired. So that's when I was put in the position of, okay, do I be a solo? Do I be an S Corp? I did not have any other owners, so I didn't have the option. I didn't have a partner, so I wasn't going to be an LLP. So I had those two options. So I hired an employee right off the bat. And the reason, even though, I was fortunately, I knew I was keeping my corporate clients because it wasn't a bad dissolution. And because of the litigation that I do, I like flexibility. I like to be able to do things and not be completely tied down to my schedule to the courts. So that was one of the reasons I started off right away having an employee. But of course, an employee is an expense. So one of the things I would recommend when you are getting ready to hire or to rent space, or when you go out on your own at all, set up a budget. Run your expenses. How much money do you want to make, or do you need to make, perhaps? What's your rent cost? I have a budget, and my budget obviously fluctuates based on the number of employees or their salary. So I can look at what's the monthly amount. Nick has a very different practice because of his being a personal injury lawyer, and he probably gets huge chunks of money at various times. Whereas my practice is much more monthly. I send out bills every month, and I generally get funds in on a monthly basis. So I have a monthly budget. And so when I got ready to hire, so I started one attorney. The next hire was a staff person. And then, you hire the next attorney. How's the workflow? And some of it is the personal choice. How much do I want to work? How much can I work? Do I have multiple court hearings at the same time? Do I bring in a contract? And as Nick said earlier, this is where it's really important to talk to someone like James, who's an excellent employment attorney, when you are going to be hiring people. You need to have you have to have payroll set up. You have to have a employer handbook. There's a lot of things when you hire, whether it's an attorney or a staff person, there are a lot of requirements. And in California, there's a lot of requirements for employers that you want to make sure you don't run afoul of. So if you're not an employment lawyer, as Nick said, talk to a professional about the issues that will likely come up. I think, you can always, if you're not sure about how much time, and there are ways you can deal with salaries or full-time or part-time. Do you use temp services? That kind of things. Those are some considerations when it's like, oh, I'm feeling a little overwhelmed. I'm a little too busy. I could really use some help. What kind of help do you need? And where can you get that? But if you're bringing them on as an employee, there are certain real requirements. So I'll let Nick kind of maybe talk about his experience with that.
Yeah, it is obviously going to be a decision that is very specific to the circumstances of the decision maker and the firm. Budget is paramount. As Danae alluded to, I work in an industry that has very erratic earnings. We can have, just based on the timeline or where our different cases and litigation are in the pipeline, a lot of quiet months in terms of income, and then cases just by happenstance are all stacked up and resolving either by way of settlement or verdict, and suddenly there's a cash infusion. But you still can budget with practically any business, even ones with kind of large peaks and valleys. You can smooth out over 6 months or a year or multiple years and get just an average, and then go from there. So you can kind of account for the dry spells, so to speak, because in the past there's going to be larger, more fertile times for the business. In terms of staffing, it really is about the firm's needs and what's important. In terms of budgeting, I think the one recommendation I would say is you always want to, whatever you think an employee will cost, it's probably going to cost 15 to 20% more than that. for all sorts of kind of unforeseen, or not necessarily unforeseen, but just for a lot of other reasons. For example, you always have to consider the benefits packages you provide your employees. That should be considered right next to their straight compensation. And in terms of benefits, you want to talk with the administrator of your benefits if you use a third party, or if you're doing it yourself, look at your plans closely. Usually you can't discriminate as between full-time employees for health benefits, for example. So you can't hire someone and say, this is compensation only and we're excluding you from health coverage, because your plan likely won't allow that. Not to, putting aside, some moral issues that probably shouldn't do that anyway, but the benefits, those can be broken down as to cost per employee. But of course, and James knows this, you don't necessarily know how much an employee's benefits are going to cost. You can't ask health questions that would give you some sort of clarity of how much this specific person is going to cost under your plan. You would be running afoul of employment laws, as well as disability discrimination potentially. So you kind of have to be going blindly. But you can make some, general approximation of how much someone's going to cost. And then there's also general costs of just having an additional staff member within the office. It's the adding an extra telephone line, any IT requirements to get their station up and running, if that's not already in turnkey. It's the extra use of postage and paper and copying and scanning. If you have kitchen snacks, how much that will wear, tax on the kitchen supplies. It sounds silly, but it does actually add up over time. And so when you're making those staffing decisions, you always want to over budget rather than under budget. The worst thing you could do is just look at straight compensation. For example, if you were looking to hire an attorney, a new associate attorney, and we're saying, oh, the community, the competitive salary is X dollars. That's what's going to cost. It's not. It's probably going to cost that plus, 40 or 50% of that salary. Danae, you've had different experiences using recruiters when you make hiring decisions. How is that? What has your experience been there?
Yeah, so one of the things we want to talk about is, when you choose someone, how do you find someone? So one option obviously is to check with your own network. Does somebody know a particular individual, depending on whether you're looking for even staff people or attorney, or if you're looking for paralegal, they may be an option, at least to start with. The other option is, obviously there are companies that will do temps to hire more, not so much with professionals. It's a little harder to do attorneys that way, but for staffing help, then you can look at your various options for where can you advertise. I guess there's, LinkedIn, Indeed, social media, what is a good option? I know different people use different sources for obtaining, but recruiters, one thing about recruiters can be extremely expensive, and they can take approximately 25% of the salary for the first year if you hire someone. If it's a key employee and you're having a difficult time, let's say you basically, if you're looking to bring in a partner, maybe that's worth it to spend that money, and but there's no guarantee that person will stay. And sometimes staffing companies will give you money, they'll find a replacement for that person. Let's say you bring in a assistant, and you pay 25% approximately of their first year's salary, not all their other benefits that Nick mentioned is the cost of the employee, but you'll pay 25% of their salary to the recruiting company. And then if they don't leave, sometimes the recruiting company will find a replacement if they haven't stayed for the full year, or depending on what the contract happens to say. There are some recruiters I have found of late that will do it. They will hourly. They will charge you hourly for finding these people. And again, if you're a solo or you don't have the time capabilities, they can, send out, they can at least do the first sift of people for you and look at the resumes. Because I understand some people have looked on done Craigslist. I have not personally done that, but they've had a huge influx of, people just from all over the place. And right now, I would say, given the current status of the unemployment, you would spend a great deal of time depend on sifting through resumes to even figure out who to interview. So sometimes there are some sources that will do that initial sifting. You tell them what your minimum things are, because you'll get people that aren't qualified apply, and they will at least narrow it down to you for you. So then you just interview the individuals, you pay them for that time, for that sifting, if you personally don't have that time. That worked really well. Again, I would consider using a more expensive type recruiter if I'm looking for a high level position, but I'm also going to have to really, back to the budget for that, because that person's going to cost me their salary, their benefits, their workstation, their everything else, plus the recruiter cost. How about you, Nick? What have you done? I know you're in the process right now of looking for hiring someone, and a paralegal.
We have a paralegal type position that does a lot of our phone intakes from calls for the public who have potential cases. They also do all of our medical records ordering and summarizing, which is really important for our personal injury practice. And historically, we've hired people that have recently graduated from college and are looking for real world experience and have an interest in law. The downside of that model is these are very bright candidates that often leave us to go to law school. I guess that speaks fairly well of our firm, that they work for us for a couple of years and are not turned off from law. They actually want to go to law school. So that's nice to know. But the problem is we have been replacing the position. It's a little bit of a revolving door. We typically have candidates stay 1 to 2 years. But for this position, because it's not a real high level position, it's not an attorney, we have often done the self-help. We post it on various sites. We haven't done Craigslist. We used to do Craigslist, but that's kind of fallen out of favor a little bit. We've done Indeed, we've done LinkedIn, has a job portal as well. We get, for this round of paralegal searches, our current paralegal is going to law school in the fall. We've gotten, I would say, a depressing number of applicants, meaning way too many. I think it's reflective of our job market. We've also received many applicants for this admin position from law graduates, meaning lawyers who are either who passed the state bar, even though this is not a lawyer position. So I definitely, even in this little experience, you can already see this recession in our field. But we do get a lot of applicants, and it does take some time sifting through all the applicants, selecting some, and then going for interviews. But as Danae mentioned, if we were to go through a recruiting service, they may save us all of that work, except generally, if you find a fit and you hire them, you could pay a quarter of the annual salary as the fee to the recruiting service. And there's no guarantee that the person's going to work out. Some of them, like Danae said, would have a replacement service, but at some point, I forget what the timeline is for a lot of these recruiting services. Once you pass a certain number of months and the person leaves, that goes away. So it does become non-refundable at some point. But for admin positions, we've generally done it ourselves and just done the legwork ourselves. and have had fairly good success. But if we were to hire another attorney, I would consider using our recruiting service, just because they're going to cast a very wide net and really get you the best qualified candidates, even if it is an expensive endeavor based on the fee, because it's an investment in the business that's probably worthwhile.
I know it's not as as well known as it probably could be, but have either of you had any applicants or folks come through the Bar Association's job board, if you're aware?
I have. I think we actually did not post on the job board for this position, but more just from forgetting to do so. But I believe we have posted on the job board for past paralegal positions, as well as for a legal secretary position. And I can't remember if we actually made the hires through that portal, but we definitely got some traction there. And that's actually a really good resource, because the people that are seeing that are members of our legal community. And so you're going to get people that have some level of vetting.
That's right. And Ann points out that there's also the JFK paralegal program, which might be a good resource for potential paralegals and staff members as well.
Yeah, I have posted, I think, for an attorney back on the CCCBA job board. I'm not sure how many non-attorney positions. I mean, Ann did mention the paralegal, but for admin positions, people that would look there for a job posting. So I think that might be, I think for an attorney, that's probably an option. And I do recall getting some applicants. I don't recall the hiring from that. But certainly it's a very reasonably priced source to at least cast a net. And that kind of goes back to the idea of your network. So somebody else might see that in our community, and assuming you work in this community of Contra Costa, then say, hey, there's a job, and then they tell someone. So even if it's not direct, so it's a great option to at least start with and start to spread the word.
Let me transition a little bit. We're coming up on almost an hour, but in terms of hiring an attorney, have either of you had to hire or hired an attorney or made the analysis of whether to hire an attorney as either an of counsel or a contract attorney versus an actual an employee or partner? And what kind of analysis did you go through for that?
Well, Nick and I discussed a little bit yesterday with contract attorneys. I think one of the challenges that I have found with contract attorneys is, now that we can, I guess, the law's changed again and we can hire them again that way, because there was a period where that was a question mark, right, James? But one of the challenges is whether or not they know your area of law sufficiently. We do very specific real estate related and business law. So usually it wouldn't be for transactional work. That would be pretty hard unless unless it was more formulaic for me to bring a contract person on. I have, when we've been super busy and it was sort of like a case getting ready for trial and didn't know if I was going to need an employee after the fact, brought in some contracts to help out. One of the challenges, though, I have found is if they don't have the specifics of our area of law, the specifics of the facts of the case, it's very difficult to bring in a contract attorney for anything that's not somewhat more generic. So I think that's been my experience with contract attorneys. I talked to some truly solo attorneys who brought in contracts in cases, but they brought that contract in from the beginning and had them basically be sort of their associate, but as a contract throughout the case. Now that might be something, that would work. But in my experience, the contract piece has not been, you just don't have the same control they work when they want, if they want. That's partly why they're a contract. And so if they're not interested in your case, or they're busy, or they want to go do something else, they may not be available to you. And oftentimes you bring that contract in because you need help and you need it now. And they're like, yeah, so that's been my personal experience. I tend to like employees better than contract, other than I brought in, temp staff people. That's like through temp agencies, just because we need them for a few days or whatever. Somebody's out sick, or that's been fine. But attorney-wise, I've not found that to be helpful.
Yeah, we've had a fair amount of success using contract attorneys, but I will say that success is because the attorneys we've used that on specific assignments and projects, for example, a large kind of work-intensive motion comes into the office that the handling attorney just doesn't have the resources or time to deal with. The contract attorneys were former employees that are now working, part-time and kind of not interested in working in a full-time capacity anymore. But these are attorneys we've known and have a track record with. We have also stepped outside of those attorneys and gone through, there's contract lawyer databases, and that has been much more spotty. As Danae and I were discussing the other day, for example, if we get a motion for summary judgment that we need to oppose, and it's going to require 40 or 50 hours to oppose it, and we just don't have the time, and we're looking to spend money on a contract lawyer, that sounds great in theory, but the problem is that contract lawyer has no experience with the case. So they don't know the facts of the case, and they would have to review every single document in the file to really get to know it, and then still may not really have, kind of a working understanding of your goals in the case. So you end up having to handhold throughout their preparation, and to the point where you've spent so much time getting the contract lawyer up to speed on what to do that it's like almost like you should have just done it yourself. But it really depends. I think the other issue in our practice, just like revenue can be kind of fluctuating greatly and very erratic, workflow is also very erratic. So we do have times where we have many different motions that are coming into the office, and we really could use another attorney, potentially an associate attorney in the office, helping with all of these assignments. And it almost pushes us to make that hire. And then we'll have months where things are really quiet on that front, and we don't have that work. And we feel like, we actually don't need that extra associate. So there probably will come a time in the not so distant future where we decide we're going to add an associate attorney to the firm. And we'll go through that search either ourselves or through a recruiting service or word of mouth. But at least on some assignments in the past years, we have relied on contract attorneys, but our success has really been specific to the contract lawyers being former employees.
And in terms of your attorneys that you've hired, what are some creative, and it may be different based on your practice areas, but is it salary only? Do you also give them like client origination credit? Do you do that only for senior attorneys and maybe not associates, or do you do it for everyone? Or what are some creative ways to compensate your attorney hires?
Sure, I can speak to that. So, I think it does depend on the attorney, because obviously a junior attorney is not likely, if they don't have experience, if they're not coming over with experience, they're not likely to bring in clients. And this gets back to, the managers of a firm, or, are they going to bring over a client that you want to bring over? Because again, if you're the owner of the firm, do you really want this case? And that would be something that, Nick, managing partner, you've got to decide is, that there's cases out there that, someone on a lower level won't necessarily be able to bring in a case that the firm wants. but I certainly, with my senior, so I have someone who's extremely senior, been practicing 30 years, and I have someone who's much more junior. So my senior counsel, she obviously brings in work, and I do compensate her. So she has a salary plus compensation for the work she brings in. I still have to approve the work she brings in, because one thing I'm very cognizant of is I want to stay within our area of expertise, which is real estate and business. And if it's employment, I'm like, nope, I don't care if I know the answer to that question, because James has told me. I'm not taking that case, because again, then you put yourself at risk for liability. So that's probably the way that I've done that, is basically, yes, as long as it's a case I'm willing to, within our area of expertise.
Yeah, and just real briefly, if we were to hire an associate attorney who was going to be a litigation support attorney who provides case support on research and writing and deposition and court coverage, that sort of thing, general associate work, it would likely be a straight salary. But if we were to bring in another partner to the LP, or maybe even a senior partner, a senior attorney who is not a partner, that would be someone that would likely be managing their own caseload, originating cases through their business networks and reputation. And we probably would have a hybrid of some sort of floor salary, or they could even be an advance on their commissions. But because of the nature of our contingency fee business, it lends itself very easily or very well to a kind of eat what you kill fee arrangement, where the attorneys that originate and handle cases, they would get a percentage of the settlement fee, and the rest would go to the firm. And so you actually could minimize the salary requirements for those attorneys. But if it was someone who was lower level general associate, that doesn't really make sense. So you'd probably be on a fixed salary.
Thank you both. We've been going for a little over an hour now, so let's turn to our final topic that we said at the outset, which is really the transition of leadership in firms and some of the ethical obligations to your clients, and also buyout agreement considerations and those issues.
Sure. So obviously, one thing is, if you are a solo owner, it's kind of in the industry a little bit too, but if you decide to be done, you're done, unless you have someone coming and taking over your practice for you. But clients ultimately are the ones who get to decide who they want to work with. So a client can say, well, I don't want to work with this person that you sent my file over, and that's completely their decision. So when you get to the point where you're ready to be done, if you're solo, regardless of whether you're a corp or just a solo, you've got to not leave your clients in a position like they have a trial coming up. Well, sorry, a trial in January. I'm retiring in December. Sorry. You've got to give them sufficient time and warning to find another attorney, or you may need to stay on and finish up that matter, because you do have ethical obligations to your clients. You cannot leave them in a situation that would be detrimental to their case. And so those two considerations are important, whether you're a sole proprietor, if you're an S Corp and you don't have other shareholders, that consideration exists as well. And even when I assume, and I'll let Nick talk about this, but even as a partnership, sometimes clients want to work with particular people, and that's their choice. Now, that doesn't mean you're beholden to work with them forever, but they could leave your firm then and go find someone else.
Yeah, when we had the transition several years ago, two of the attorneys or former shareholders, one being my father, Stan Casper, and one being Mike Meadows, they decided they didn't want to litigate cases. They still remain of counsel and have their name on some pleadings on some cases and are in an advisory role to the firm. But they had wound down their caseloads, but they still had some cases. Our cases can take multiple years. So they really had two options. They could either continue on those cases, or we could sit down with the client and on those remaining cases, say the handling is going to be changed to another one of the attorneys in the firm. But we did have to have those conversations on all of those existing clients, and get sign off. And because of, well, you know, what I consider the quality of all the attorneys in the office, we really did that without incident. But we did have to ensure that there was client sign off and approval. We did not want to have a situation where someone is just, you know, learns that the handling of their case has changed. And then the last thing I'll say, there's really two governing documents for our business. It is the partnership agreement, which is our formation document, which sets out, you know, management of the firm, ownership interests, succession, et cetera. And then it's the buy-sell agreement or the buyout agreement. That's with the outgoing partners. The firm was not a gift that was to us. We have ongoing financial obligations to the outgoing partners. And that document really governs, you know, our arrangement with the prior entity. They also had, interestingly, at the point of transition, the caseload in the office, let's say there's 100 cases in the office, and let's say 25, 30 of those cases are cases that I've personally worked with for the last, you know, I handled the cases entirely. That case is still owned in its entirety by the old firm. So we had to have some sort of agreement on every single case as to what percentage the old firm was going to get on each case as it settled, what percentage, and that might change over time. So the way we ended up doing it is if it settled within X number of months, their interest would be X, and then if it settled after that, it would be Y. So it was kind of a graduated thing that was decided on each case. But the buy-sell agreement was really important, and something we're still, you know, a part of. The agreement lasts for a number of years.
Wonderful. Thank you both. I know we're scheduled to go to 11, but we still have a few minutes. Are there any other questions? And if so, feel free to raise your hand or type in the chat box. But otherwise, you know, like I mentioned, we will be, or Ann Wolf will be sending out the chart that Danae and Nick created, and perhaps some other comments as well. Take it over, Ann.
Well, great. Thank you, guys. That was really informative and timely, and I appreciate you taking your time today to do this for us. And thank you to the attendees for joining us for this today.
We do have
any other questions? I don't see any other questions. Anyone?
Yeah, we just received one, and the question is, have you ever hired anyone directly out of law school? And if so, what was your experience?
I know I have not personally, but the firm has. And it worked out for quite a few years. It was a success. The upside is you have someone that hasn't gotten any bad habits from other firms. You can really mold them and litigate. They don't have to unlearn any things. The downside is obvious, that they really don't have, in our world, any litigation experience, and you really have to teach them come from the ground up. So it required a tremendous amount of resources and training and getting them up to speed over years. But it is nice to have someone that is smart and kind of a blank slate.
Yeah, and I did, one of my associates was recently out of law school, had done some contract work before, and as Nick said, they don't have any bad habits. They can learn it the way that you want it done. But there is the challenge that, you know, law school does not prepare you necessarily for the actual practice of law, and, you know, billing or certain things that you have to do in a law firm. But it was a good experience. And the only reason he's still not working with me is he moved up to Sacramento. Although now I guess virtually he probably could, since that's the way we're working these days.
Okay, anything else? I don't see anything. James, do you see anything else?
I don't. Good
Okay.
questions, though. Thank you all.
Yeah. Thanks, everybody. Have a great weekend. And we look forward to seeing you on June 9th for the civility program. So thank you very much for joining us.
Thank you, Nick. Thank you, Danae.
Thanks, everyone.
Guys, have a great
good
day.
weekend.
Bye, Ann. Thanks.
Bye, guys.